I think we're ready now to resume. Mr. Moffat.
Good afternoon, my lord. Thank you. My lord, what I propose to do now, again, if it's convenient to the court, is to move on to the third main theme of my submissions, which is really the main theme, and it's the correct approach to the common law challenge. As I understand the Southern Court's the case, it's agreed that the starting point here is Gillick, and what I intend to do is to spend a little time going through Gillick. What I'm going to do is I'm going to seek to make four main propositions in this section. Firstly, that the challenge to the guidance has to be grounded in a conventional public law ground of challenge. Secondly, the only such ground of challenge that is realistically open here is a Gillick type challenge. Thirdly, that a Gillick challenge requires the appellant to show that the guidance in effect positively advises the police that they are entitled to act in a way that is unlawful. It does not entail any assessment of risk. And fourthly, there's no authority to support the application of a significant risk type test in this sort of situation. So if I can start with Gillick, if I may, because my Lord Reed, I think my Lord Sales made the point in question to the learned friend that Gillick is not concerned with questions of risk, with questions of guidance creating a risk of unlawful activity. And with respect, that's absolutely right. One gets that not just from the wording that was used by the House of Lords, but also by looking at the approach that they adopted to the facts in Gillick, which is quite important to understand what they meant when they talked about guidance which permitted or encouraged unlawful conduct by another body. Gillick, your lordships will say that's electronic page 832. It's behind tab 3 of the first volume of authorities. As the court will be well aware, it was a challenge to a non-statutory memorandum issued by the Department of Health to health authorities. It was non-binding advice issued by the department to health authorities and for use by doctors. One point just to note, because it explains some of the discussion in the judgments, it's a claim that originally predated O'Reilly and Macman, and it was brought by a writ action, not by way of a claim for judicial review. And in essence, the memorandum advised that a doctor could prescribe contraception to a child under 16 without their parent knowing or consenting to that. And the question for the House of Lords was whether or not that memorandum was lawful. Can I start, just take it through the judgments in turn? I start with Lord Fraser, and his judgment begins at page 850 of the electronic bundle. And if I can pick it up over the page on 851, I'm sorry, I've been asked to turn my camera off and turn it back on. Apparently I'm not coming through very clearly, which could be caused by fault rather than the electronics. So I've been told to stop my camera and start it again. I don't know if that has cured the problem.
I can see you.
I'm assuming unless I'm told otherwise that's okay. Yes, I've been told it seems better. I'm grateful. So yeah, sorry, I was on page 8, electronic page 851. And just to pick it up at just below letter D, and here Lord Fraser was dealing with what he referred to as procedural matters. And he said the declaration which claimed against the department to the effect that the advice given and the guidance was unlawful amounts to an assertion that the Secretary of State has acted illegally in the sense of ultra vires. The remedy claims in the field of public law and therefore O'Reilly and Macman, which had since the decision in the lower courts been decided, needs to be considered. So just pausing there, the prism through which Lord Fraser viewed the claim was in terms of, in essence, the powers of the Secretary of State to issue the memorandum. Was the Secretary of State committing what at that time was regarded as a conventional public law error when he issued the memo? Lord Fraser set out the terms of the memorandum from the bottom of page 851 over onto 852, and it was really the final paragraph that was the contentious one, which your lordships will find on page 852 next to the letter E. And it's the department advised that in such exceptional cases, the nature of counselling must be a matter for the doctor or other professional worker concerned, and the decision whether or not to prescribe contraception must be for the clinical judgment of the doctor. And we can see between the letter F and G that Lord Fraser sets out his understanding of the advice that the memo was giving. Beg your pardon. In my view, it's perfectly clear it would convey to any doctor or other person who read it the decision whether or not to prescribe contraception was in the last resort a matter for the clinical judgment of the doctor, even if the parents had not been informed and consulted, and even if they'd expressed disapproval. So it's just worth pausing there and noting that what the memo was doing in this case, it was in effect advising that a particular course of action would be lawful, but it didn't specify in exactly what circumstances it would be lawful. And in view of some of the phraseology, the permit, encourage, authorize, approve phraseology used by the House of Lords, it's important to note that the advice wasn't actually exhorting doctors to do anything. It wasn't telling them that they should be doing something. It was merely advice about what they were entitled to do. Lord Fraser identified 3 questions that he considered needed to be answered, and he set those out at page 854 between letters F and G. And the first question that he identified was whether or not actually a girl under 16 would have capacity to consent to advice or treatment in relation to contraception. And he began to answer that at the bottom of page 854. And it doesn't really concern us the reasoning that Lord Fraser had for coming to his conclusion, but we need to note his conclusion, which is at page 857. And it's right at the bottom of the page, just below the letter H. And he says there's no provision which compels him to hold that a girl under the age of 16 lacks legal capacity to consent to contraceptive advice examination, provided she has sufficient understanding and intelligence to know what they involve. So the way Lord Fraser looked at it was sufficient if in some cases a girl would have capacity for this stage of the points that he was considering. And that's a theme that emerges throughout his judgment. It's sufficient if in some cases what the memorandum was advising would be lawful. And we see that again with the second question that he asked. And we see the heading for that again on page 858, just below the text that I've just referred to. And again, the reasoning isn't material for present purposes, but we go through to the conclusion on the second question, which is at page 862. And if I could take the court to just below the letter C on page 862, Lord Fraser says there may well be cases, and I think there will be some cases, where the girl refuses to tell the parents herself or to permit the doctor to do so. And in such cases, the doctor will, in my opinion, be justified in proceeding without consent or even knowledge, provided he is satisfied of the 5 matters that Lord Fraser there lists. So again, in relation to his second question, what he is in effect saying, well, there are going to be some cases where the course of action referred to in the memorandum won't be unlawful because it won't infringe parental rights. He's not looking at risk. He's not looking at the memorandum having to say, or it having to be lawful in all cases. It's sufficient that in some cases it's going to be lawful. And he adopts the same approach in relation to the third question, which he starts to deal with towards the bottom of page 862. Your lordships will see the heading there about criminal liability. Would the doctor be acting in a criminal way if he followed the guidance, he or she followed the guidance? And just below the letter H, Lord Fraser says this, that in the courts below, both sides conceded that whether or not there would be an offence would depend on the circumstances. And over the page, he says he thinks it's unlikely that there would be an offence but obviously he can't rule it out because it depends on the circumstances. So on the facts, it's quite important to note how Lord Fraser approached the issues. He wasn't asking whether there was a risk that the memorandum would give rise to unlawful acts. Indeed, it's implicit in his decision on the substantive issues of law that he considered that there was a risk, because all he said was that there were some cases where it would be lawful to follow the advice. And the memorandum, by not being specific about the circumstances to which it related, didn't on its face limit its application to those particular cases that Lord Fraser identified. So in essence, what Lord Fraser was doing, he was asking himself whether the memorandum was positively advising doctors that they were entitled to do something that was unlawful. Lord Scarman, his speech begins at page 864, the next page. And if I can pick it up, he agreed, we see from the beginning of his speech, he agreed with Lord Fraser, but if I can pick it up from page 865, and we can see a heading there, procedure. And again, this is dealing with the mechanism by which the claim had been brought, the O'Reilly and Mackman procedural exclusivity point. And if I can pick it up just above the letter E, Lord Scarman says this: it was not continued that the issue of the guidance was a crime. The case against the department was simply that the guidance, if followed, would result in unlawful acts, and that the department, by issuing it, was exercising a statutory discretion in a wholly unreasonable way, i.e. classic Wednesbury unreasonableness. So again, a point to note there is that Lord Scarman is framing his approach to the guide to the memorandum in terms of the Secretary of State's powers. Again, a conventional public law approach to the exercise of powers. And it was that gave rise to the procedural exclusivity point that their lordships resolved in favour of Mrs. Gillick. They said the claim wasn't an abuse of process. Can I then go, if I may, to page 867 is where Lord Scarman starts to consider the terms of the guidance. And my Lord Sales has referred to the question that Lord Scarman poses in page 868. What is the true meaning of the text? So again, as my Lord Sales points out, Lord Scarman wasn't looking to see, well, what are the range of possible interpretations that a doctor might put on this text? He's looking for one definitive interpretation. Now, of course, that might involve reading it through the eyes of a reasonable doctor, but it doesn't mean speculating as to what all possible people might read the guidance as saying. And then if I can go on to page 869, just again to highlight a point on the facts here. And it's just it's the two paragraphs that begin just above the letter B. And Lord Scarman says this: the guidance leaves two areas of the doctor's responsibility in some obscurity. Although it provides illustrations of exceptional cases, it offers no definition. And it gives no clue as to what is meant by clinical judgment, other than it must at least include the clinical judgment of a doctor as to what is the medically appropriate course for that patient. This lack of definition does not assist Mrs. Gillick. If contrary to submission, the law recognises that exceptional cases can arise in which it is lawful for a doctor to prescribe contraceptive treatment without the knowledge and consent of a parent, the guidance would be within the law, notwithstanding its lack of precision, unless its vagueness created so obscure a darkness that it could reasonably be understood by a doctor as authorising him to prescribe without the parent's consent whenever he should think fit. So again, Lord Scarman saying there, well, it doesn't matter if the guidance is a bit vague. It's only problematic if it's so vague as to be positively misleading. And when one comes to the passage that my Lord Reed focused upon this morning, between the letters F and G, one has to read that passage in the light of what Lord Scarman has just said about vagueness and obscurity. It's only if the guidance permits or encourages unlawful conduct in the provision of contraceptive services that it can be set aside as being the exercise of statutory discretionary power in an unreasonable way. The question, therefore, for the House is, can a doctor, in any circumstances, lawfully prescribe contraception for a girl under 16 without the knowledge and consent of a parent? So, picking up 2 points from that short passage there, if I may. Firstly, the focus on the Secretary of State is only acting unlawfully. The memorandum is only unlawful if it permits or encourages unlawful conduct. As I've said, that has to be read in the light of what Lord Scarman said above. The fact that the memo is simply vague about what constitutes lawful or unlawful conduct isn't enough to bring it within that formulation. The memo has to positively advise that doctors were entitled to do something that was unlawful in order to fall within what Lord Scarman meant when he talked about permitting or encouraging. The second point I take from that short passage is in relation to the way that Lord Scarman asked whether in any circumstances it would be lawful to follow the advice. If there were any circumstances in which the advice could lawfully be implemented, the memorandum would not be unlawful. So again, it's clear that Lord Scarman was not posing a risk-type test. Again, if anything, quite the opposite. What he was asking was not whether there's a risk that it might be implemented unlawfully. He was asking whether there was a possibility that it could be implemented lawfully. So in a way, the complete converse of the test that Mr. Southey is arguing for in the present case. On the matters of substance, Lord Scarman adopted the same approach as Lord Fraser. And if I could take the court through to the end of towards the end of his judgment at page 876, if I may. And at the very bottom, just below the letter H, Lord Scarman says this: in light of the foregoing, I'd hold that as a matter of law, the parental right to determine whether or not their minor child below the age of 16 will have medical treatment terminates if and when the child achieves a sufficient understanding and intelligence to enable him or her fully to understand what is proposed. So again, what Lord Scarman is saying there, well, it really depends on the facts, whether or not the parent's right, parental right in relation to the child is extinguished in a particular case. It will be a question of fact whether a child seeking advice has sufficient understanding of what is involved to give consent that is valid in law. And then he goes on to give certain examples of this. And then in the following passage, letter C on page 877, when applying these conclusions to contraceptive advice and treatment, it has to be borne in mind there is much that has to be understood by a girl under the age of 16 if she is to have legal capacity to consent. And then he goes along to give examples. So again, in substance, Lord Scarman is adopting the same approach, or coming to the same conclusion as Lord Fraser. What he's essentially saying is, well, there will be some circumstances in which it will be lawful to follow the advice in the memorandum, but it definitely won't be in all circumstances, because there are lots of things that have to be satisfied before a girl under 16 will have the requisite capacity to consent to the treatment. And then his conclusion on page 878, just below the letter B, I am therefore satisfied that the department's guidance can be followed without involving an infringement of parental right. So again, Lord Scarman, as a matter of substance, was approaching this on the basis that the question was whether or not the memorandum could be implemented in a lawful way. He was most definitely not looking at whether or not there was a risk that it might be implemented in an unlawful way. And I then go to Lord Bridge. His speech begins at page 879 of the electronic bundle. And at the top of page 880, he reflects upon what he saw as a fundamental difficulty in the case, and he articulates that just above or between the letters B and C on page 880. And he asked himself, what is the nature of the action or decision taken by the department in the exercise of a power conferred upon it, which entitles a court of law to intervene and declare that it has stepped beyond the proper limits of his power? So again, pausing there, Lord Bridge adopting exactly the same approach as Lord Scarman and Lord Fraser, looking at this through the prism of conventional public law powers. That's his starting point. Has the Secretary of State acted unlawfully? The point that concerned him, he articulates at the bottom of that bottom of the next paragraph, next to the letter E, and it was the fact that the memorandum wasn't issued in the exercise of any statutory power or in the performance of any statutory function. It's purely advisory, and practitioners in the NHS are, as a matter of law, no way bound by it. And then he goes on to say, in those circumstances, next to the letter F, review on Wednesbury grounds was not available, because that requires one to look at the nature of the statutory power that is being exercised. And then over the page on 881, at the end of the first paragraph, just below the letter A, he concludes the question whether the advice tendered in such non-statutory guidance is good or bad, reasonable or unreasonable, cannot as a general rule be subject to any form of judicial review. Now, pausing there, of course, things have moved on since the decision of Gillick in terms of amenability and grounds of challenge and what have you. But again, Lord Bridge very clearly viewing the issue of the legality of the guidance through the prism of the lawfulness of the exercise of the power by the public body that issued the guidance. And this is what he said. This is how he cut the knot that he saw to exist. One can pick it up at the bottom of page 881. Having referred to the Royal College of Nursing case, at the paragraph that begins just above the letter G, and the second sentence, I think it must be recognised that the decision in the Royal College of Nursing case does affect a significant extension of the court's power of judicial review. We must now say that if a government department in the field of administration in which is exercised a responsibility promulgates in a public document, albeit non-statutory in form, advice which is erroneous in law, then the court has jurisdiction to correct it. So again, pausing there, the way Lord Bridge formed the problem with the memorandum was error of law. Again, perfectly conventional public law ground of challenge. He went on to caution in the rest of that paragraph over to the top of page 882. He went on to caution against considering challenges in circumstances where they would involve social and ethical controversy, but also at the end of the paragraph, he cautioned against proffering answers to hypothetical questions of law which do not strictly arise for decision. So Lord Bridge invoked the concept of misdirection, again, perfectly conventional ground of review. And he cautioned against delving into hypotheticals. Well, delving into hypotheticals is exactly the sort of exercise that's likely to be required if the court is going to determine whether there is a risk that guidance gives rise to unlawful action. It's exactly the kind of speculation that I referred to before the lunchtime adjournment. But again, in this context, even though Lord Bridge attached a different label to the legal error, one can see that in substance his approach was the same as Lord Scarman and Lord Fraser. If I can pick it up at letter D on page 882, this is what he said: to succeed in her action against the department, Mrs. Gillick must at least establish that, leaving aside cases of abandoned children's emergencies, the law does absolutely prohibit the prescription of contraception in the circumstances envisaged by the memorandum. So again, he's not asking whether there's a risk of unlawful action. He's asking whether, in effect, unlawful action is inevitable as a result of the memorandum. So again, in substance, a very similar approach to that adopted by Lords Fraser and Scarman. And on the substance, Lord Bridge agreed with Lords Fraser and Scarman, and he concluded that the law did not absolutely prohibit the course of action contemplated by the memorandum, and one gets that from the final part of his speech on page 883. So I'm sorry this is taking so long, but I think it's important to recognise the way that the House of Lords approached the matter on the fact. Lord Brandon at page 883 dissented. He didn't touch on any particular issues that are relevant for present purposes, because he held that it was unlawful to prescribe contraception to under 16s in any circumstances whatsoever. And the reference for that is page 887 next to the letter B. So for him, none of these issues particularly arose, because for him the law was in absolute terms, and it was in absolute terms against the memorandum. Finally, we have Lord Templeman, who also dissented, and his speech begins at page 887. And if I could take the court through, if I may, to page 892. He says this about the course of action contemplated by the advice. Although a doctor is entitled to give confidential advice to an infant, the law will, in my opinion, uphold the right of a parent to make a decision in which the infant is not competent to make. The decision to authorise and accept medical examination treatment for contraception is a decision which a girl under 16 is not competent to make. So Lord Templeman's conclusion on the substance was again that, in effect, it was inevitable that the course of action contemplated by the advice would lead to unlawful action by doctors, because girls under 16 simply were not competent to take decisions in relation to contraception. And that's one has to read the passages that follow in that context. If we can go to page 893, first of all, between E and F, we have that conclusion translated into his conclusion as to the lawfulness of the memorandum. In the present state of the law, the memorandum appears to me to be defective. The principal defect lies in the assertion that the decision whether or not to prescribe must be for the clinical judgment of the doctor. In my opinion, a decision by a doctor to provide contraceptive facilities for an unmarried girl of 16 against the knowledge or wishes of a parent would constitute an unlawful interference with the rights of the parents, subject to the intervention of the court to make that decision on behalf of the girl. So Lord Templeman's conclusion on the substance was that, again, what the memorandum was contemplating would in no circumstances be lawful, because there couldn't be, as a matter of law, consent from the girl who would be prescribed contraception. And that's when we get to the passages that my Lord Reid discussed with Mr. Southey this morning on page 894. And we see there, just below the letter C, those defects constitute a mistake of law on the part of the department. So again, we see this theme about, well, it's all about the exercise of powers by the department in issuing the memorandum. And then he explains why that is. And then he says, if the memorandum is defective by reason of a mistake of law, and if in consequence a doctor making a decision in reliance on the views expressed in the memorandum may unlawfully interfere with the rights, then in my opinion, the DHS, which is responsible for the memorandum, is amenable to the remedies of judicial review. Now, I think Mr. Southey picked up on the use of the word may in that passage, but it's very clear from the route of reasoning that Lord Templeman follows that he is not using may in the sense of risk. He is not bringing into play any sort of level of risk there, because on his view, it automatically follows from the memorandum that the course of action contemplated would be followed. It might or might not happen in a particular case, but if it does happen, it is inevitably unlawful. And we see, just following that passage on a bit, we see some language that is reminiscent of Lord Scarman next to the letter F. He says this: the issue is not whether the department are exercising a statutory discretion in a reasonable way, but whether by mistake of law the department, a public authority, purports by the memorandum to authorise or approve an unlawful interference with parental rights. Again, that appears to reflect what Lord Scarman was saying earlier on in his speech. And we see from the bottom just a final point to pick up from the speeches. At the bottom of page 894, just below the letter H, he says this: the danger that other parents or individuals may exploit judicial review proceedings by referring social problems to the court or by seeking general pronouncements of law based on hypothetical facts can be averted by the exercise of the judicial discretion to refuse permission for the proceedings to be brought. So Lord Templeman again cautioning against using challenges to guidance as some sort of vehicle for exploring hypothetical cases and hypothetical facts.
It's interesting that Lord Bridge makes it clear that in his view, because the guidance was not issued in the exercise of a statutory power, there was no question of applying Wednesbury principle, because there were no relevant factors or irrelevant considerations or improper purposes and so forth. And so the issue resolved itself into whether there was an error of law. And Lord Templeman seems to be taking the same approach. But below E, he says it doesn't matter, it matters not whether the memorandum constitutes an order or guidance or advice or a mere expression of view. So you're not in the realm of the exercise of statutory powers and therefore of vires. It's rather provision of advice and a question whether the advice is based on a mistaken law.
Yes, I mean, look, if I can make one thing absolutely clear, so there's no mistake about this, I'm absolutely not saying that this guidance is not amenable to judicial review.
No.
However, and this was
no, but what comes out of it is that it may be a judicial review on not the same range of grounds as would be available if this were a more conventional exercise of a statutory discretion.
Your Lordship is absolutely right. And I was going to draw 3 points from Gillick. And if I could perhaps, because your Lordship's raised it, deal with that one first. The Lordships in Gillick characterised the issue or viewed the issue through the prism of whether or not the Secretary of State had acted unlawfully. Now, they did so in different ways. They approached it, some referred to Wednesbury, some referred to error of law. And it might not matter for present purposes which particular box it goes into. But the point is that what the House of Lords were doing, as my Lord has just pointed out, is they were testing the lawfulness of the memorandum by reference to conventional public law grounds of challenge, or by reference to the scope of the power of the Secretary of State that was being exercised in issuing the memorandum. And we say that is obviously correct. The issuing of a measure such as whether it's the memorandum in Gillick, whether it's the guidance in this case, is the exercise of a public function by a public body. And there is no special unique category of rules that apply to the assessment of the lawfulness of such measures. It doesn't matter whether you characterize it as a challenge to the guidance or a challenge to the decision to issue the guidance. As a matter of substance, the approach is the same. You look at the powers that were being exercised and you test the lawfulness of the exercise of those powers against the grounds that are available. And as my Lord Reid has pointed out, those grounds will differ according to the powers that are being exercised. And as Lord Bridge pointed out, and as is the case here, where in effect what is being exercised are common law powers, then the grounds of review that are open are generally narrower. And we've referred in our written case to the decision of this court in the Sandiford challenge and Lord Sumption's comments in there. So the point, and the reason I stress this point, and it picks up on a question that my Lord Reid asked Mr. Southey this morning, is that whatever approach, whatever test is being proposed has to be grounded in what I would call for shorthand a conventional public law ground of challenge. One can't simply pluck a test out of thin air and apply it willy-nilly to a whole range of different circumstances involving a whole range of different exercises of different types of powers, whether they be statutory, whether they be common law, whether they be, who knows, prerogative in some cases. And one of the difficulties, frankly, with some of the case law of the courts below is that it doesn't always seize upon that particular starting point, which is got to be the jumping off point for the analysis. Because without knowing what powers are being exercised and what sort of grounds are available in relation to that exercise of power, one can't even start to contemplate what potential errors might have been committed. It's to put the cart before the horse. So, I mean, Mr. Southey in his supplemental note suggested that we were seeking to erect some sort of artificial distinction between a decision to issue guidance and the lawfulness of the guidance itself. It's quite the opposite. What we're saying is, well, essentially it's the same thing. And that comes through. I mean, we would say it's fundamental public law, but it's also very clear, as long ago as Gillick in the mid-1980s, that this was the approach to be adopted. So I'll come on to develop this a little bit if I have time, but for Mr. Southey to say, oh, well, there's a case over here where they pose the significant risk test, and there's a case over there where they pose the significant risk test, or there's another case where it was inherently unfair, is with respect simply not good enough. One has to go back to first principles, and one has to say, well, what was the public law error? Why is that the test? And a prime example of this, if I may, is that, and I think my Lord Burnett was involved in one of these cases, was, off the top of my head, I can't remember which case it was, but one of the systemic unfairness cases related to the common law right of access to the court. And the Court of Appeal approached it on the basis that the test was the one that was applicable if there is an interference with that right. And the appropriate approach in that context was whether or not there was inherent unfairness in the scheme that had been set up. I believe it was the exceptional case funding challenge, the Director of Legal Aid casework. Now, in that case, there's a clear jumping off point for the test that's being applied. It's being grounded in a conventional public law ground of challenge. Here's a function which is being exercised in a way that interferes with common law rights when there's no statutory warrant for doing so. Perfectly orthodox principle of legality, ex parte sims approach. But with respect, that's not always the case in some of the case law courts below. And again, with respect, it's a flaw that has seeped into my learned friend's arguments, because he's got to start and say, right, well, we are challenging this on the grounds of irrationality. We are challenging it on grounds of error of law. We are challenging it on grounds of whatever the ground might be, but he's got to identify a conventional public law ground of challenge to even get this claim off the ground. And I think that was maybe, perhaps I'm being a bit presumptuous, but I think maybe that was the thrust of my Lord Reed's question this morning about, well, what is the ground of challenge here? So that's why I say that is important, and I entirely adopt the point that my Lord Reed put to me about Lord Bridge. It shows precisely why it's important to identify the starting point for the challenge. Because if you don't have that, everything that follows is built on sand. So well, that was going to be the third proposition I was going to get from Gillick, but you anticipated. Can I draw two other propositions from Gillick, if I may, or two other points that emerge? Firstly, the general way that Gillick is described in the authorities is that it is authority for the proposition that guidance will be unlawful if it permits or encourage unlawful conduct. And my Lord Sales referred to the Bayer case and the slight gloss that was put on that in relation to sanctioning unlawful conduct. And that's the wording that was used by Lord Scarman, and we saw similar wording used by Lord Templeman. But one has to understand that formulation in the light of the way it was applied in some sense. It's not a statutory test. One has to understand it on the basis of what their lordships were doing. And what their lordships were doing, as is plain from their decision on the facts, is asking whether or not the memorandum positively advised doctors that they were entitled to do something that was unlawful. there is no way that the Gillick decision, any of their lordships' judgments in Gillick, can be interpreted as somehow applying a risk type test, because as I've sought to show the court, it is implicit in the judgments of the majority that the memorandum did give rise to it. If applied, there was a risk that the conduct would be unlawful, because the memorandum wasn't specific as to the circumstances in which it would be lawful or unlawful to prescribe contraception to under 16s. On its face, the memorandum could have led to lawful or unlawful consequences. But it was enough for the Secretary of State to leave it to the health authorities, to leave it to the doctors to distinguish between the two. So that's the first point. Oh, sorry, if I conclude on that point, actually, that approach to Gillick is supported, we say, by the case that my Lord Sales referred to, the Bayer case. That was a case where a clinical commissioning group issued a policy which envisaged that NHS trusts would obtain a particular drug to treat an eye condition. On the facts, there were lawful and unlawful routes for the trusts to obtain the drug, but the policy didn't advise them as to which way they should obtain it. It didn't advise them as to which routes they should adopt or which routes would be lawful or unlawful. And if I could, I won't go to it, but if I refer the court, it starts at page E96 of the bundle. And if I could refer the court, it's just paragraphs 196 to 207 in Lord Justice Underhill's judgment, and paragraph 214 in Lady Justice Rose's judgment. What they said in express terms was that the policy wasn't unlawful because it left open the possibility of being implemented in an unlawful way. What they looked for is whether or not the policy was promoting an unlawful course of action. That was Lord Justice Underhill in paragraph 200. And Lord Justice Underhill said this in paragraph 200: I can see no principal basis on which the policy should be treated as unlawful simply because it does not prescribe the lawful alternative and proscribe the unlawful. It neither leads to nor encourages the choice of the unlawful route. Excuse me. So the Court of Appeal there clearly approaching Gillick in the way that I have sought to outline it to your lordships. So that's the first point. The second point I've rather made already in passing a number of times. There is nothing in Gillick that is authority for the test put forward by Mr. Southey. And indeed, on the facts, Gillick stands foursquare against the approach advocated by Mr. Southey. So, my lords, that is Gillick. I'm sorry it's taken so long to go through it, but I think, as I said before, it's important to understand what the House of Lords were doing in the context of their conclusions on the substantive issues in Gillick, because it really shows the quite limited approach that they were adopting to guidance in that case. So if I can then move on to two other topics in relation to the common law challenge, and I think I can take these fairly quickly. Firstly, in terms of the significant risk test that the appellant's arguing for, as I said, that needs to be grounded in some conventional public law ground of challenge. Now, Mr. Southey didn't mention this in his oral argument, but in his written case and in his supplemental note, he relies heavily on the case in the Court of Appeal of BF Eritrea as authority for that test. Now, I'm conscious that this court is due to hear an appeal in BF Eritrea next month. So, of course, the decision as to whether or not it's correct is a matter for another day, and I won't say anything about that. For present purposes, I'll take it at face value. But we say, even taking it at face value, there are three reasons why BF Eritrea doesn't lay down a test of more general application. And I won't take the court to it in interest of time, but if I can just give you the 3 points, if I may. Firstly, Lord Justice Underhill, who gave the lead judgment, expressly stated that the approach that he was applying in that case was the correct approach in the circumstances of the case. That's at paragraph 63. So the Court of Appeal in that case wasn't even purporting to lay down a test of general application. The second point is Lord Justice Underhill expressly stated that the test that he was applying was not based on any analysis of authority. Again, that's paragraph 63. I do not think that it is necessary or useful to analyse the various cases referred to. So again, another indication that the court was not seeking to lay down a test of more general application. And thirdly, Lord Justice Underhill did not ground his test in any recognised category of public law error. So again, an indication that what the Court of Appeal said in the BF case cannot be read more widely. On its own terms, it was very much concerned with the unusual specific facts of BF Eritrea. In terms of the significant risk test, there is also a practical problem with it. It raises the real question of, well, if that's the test, how is the court meant to evaluate the nature and the extent of the risk? Mr. Southey positively put forward the point that this involves a predictive exercise. But one can easily see that's going to be a very difficult exercise for a court to engage in. On Mr. Southey's case, the first thing that the court has to do is it has to identify the range of meanings that different people might ascribe to the guidance in question. And that's only the starting point, because it must follow from there that the court then has to ask, well, how will different people act on the basis of all those different potential understandings of the guidance? And then, having done that, the court would have to think about what the potential consequences are of all those different people potentially acting in all those different ways based on all those different understandings of the guidance. This is a simply impossible exercise for a court to engage in. It would just involve an exercise in pure speculation. It is very difficult to see what evidence any party, claimant or defendant, could possibly adduce on these issues to give the court any confidence that it was reaching a view that had some support on those matters. So we say that there are, firstly, there's no support in Gillick for the claimant's test. Gillick is against the test. BF Eritrea cannot be read more widely on the assumption it's correct. The test itself is fraught with difficulty. And for all those reasons, there's simply no basis for applying it in this case. And if I could just make one more point about BF Eritrea, it's important to be clear as to the precise nature of the test that the Court of Appeal articulated in that case. Again, this is paragraph 63 of Lord Justice Underhill's judgment. The test that Lord Justice Underhill applied was whether or not the policy created a real risk of a more than minimal number of unlawful decisions. The court was not concerned with looking to see whether or not the policy eliminated a risk that might otherwise exist. It was about the policy itself being the origin of the risk. So if my learned friend's going to adopt BF Eritrea, it has to apply it on its terms. The final general point that I want to make, if I may, in relation to the common law common law ground of challenge, is that it's never been suggested by the appellant. And I think, in fairness to Mr. Southey, he expressly disavowed this suggestion in his submissions this morning. But it is not being argued that where one public body gives guidance to another public body, the guidance has to eliminate the risk of the second public body acting unlawfully. And there is no authority to that effect. Can I just make two short points about this? Firstly, such an approach would in effect involve the imposition of a positive duty on the first public body. And there's no basis for imposing such a positive duty. And again, this was a point that was made in the Bayer case, And again, if I could just give the court the references, it's paragraphs 200 to 208 of Lord Justice Underhill's judgment, and paragraph 214 of Lady Justice Rose's judgment. So that's the first point. There's no basis. It would involve imposing a duty, and there's no basis for that duty. The second point is, well, again, it would give rise to real practical difficulties. A public body issuing guidance to another public body, and there are legions of examples where this is done, whether because it's required by statute or because it's simply seen as a good, sensible way for improving decision making and ensuring consistency of approach and matters like that, is that the issuing public body would have to sit down and work out all the ways in which the addressees of the guidance might act unlawfully, and it would have to deal with them in the guidance. Now, that's going to make it very difficult to produce guidance, and if nothing else, is going to result in guidance being incredibly unwieldy and voluminous. So again, there are practical reasons why such a duty should not be imposed. Again, I don't think Mr. Southey's arguing for such a duty, but just in case he is, that's my response to it. So coming back to my four propositions, what we say in relation to the common law is, firstly, the challenge has to be grounded in a conventional public law ground of challenge. Secondly, the only ground of challenge that's realistically open is a Gillick type challenge. Thirdly, the Gillick type challenge has to show that the guidance is positively advising the police that they're entitled to or they should be acting in an unlawful way. Fourthly, the test articulated in BF Eritrea is simply not applicable. But even if it is applicable, it requires the appellant to show that the guidance creates a significant risk, and there would need to be some evidence to that effect. So, excuse me, that's all I wanted, unless there's anything further from the court on that, that's all I wanted to say about the common law ground of challenge. If I can then move to the Article 8 ground of challenge, which I hopefully can take a little bit more quickly. As I understand it, the appellant is not claiming that the guidance in itself constitutes some sort of interference with his Article 8 rights. So there are two ways of approaching the Article 8 challenge, or the Article 8 element of the challenge. Firstly, as I think it was my Lord Reed who pointed out, it's simply another aspect of the common law challenge. It's simply another species of unlawfulness that the guidance is said to give rise to. And that would have to be approached in the Gillick way. Is the guidance advising the police to do something that would be a breach of Article 8? So that collapses back into the common law challenge, and I've said enough about that. The other way is that the guidance itself is inherently incompatible with Article 8. And that's the point that I want to deal with now, if I may. We've set out in our written case what we say is the correct approach to judging whether or not a measure is in itself incompatible with Article 8. I think the appellant agrees that that is the approach to be adopted in legislation challenges. I beg your pardon, I think we've lost Lord Reed. Sorry, my lord. It doesn't instill confidence when one of the judges walks out in the middle of your submission.
I had to turn down a heater. That's all.
Well, yes, I've seen the snow arrive here in South London, and so it's definitely cold outside. Anyway, sorry. As I understand it, really the dispute between the parties in this respect is actually quite a narrow one, although potentially significant for the purposes of this case. As I understand it, there's no dispute as to the approach that's to be adopted to assessing whether legislation is inherently incompatible with Article 8. Where we part company is that the appellant says that there's a different approach that's applicable to measures such as policies and guidance. Now, we've set out the approach that we say applies in our written case, and it's really from paragraph 64 onwards. And I rather expect the court's quite familiar with this, so I'll take it fairly quickly and come to the point of difference. Firstly, the approach is to apply the conventional four-stage proportionality assessment set out by my Lord Reid in Bank Malat. However, because it's well recognised that on an in-principle challenge to a measure, there are no concrete facts on which the proportionality assessment can bite, and the court simply doesn't know whether or in what sorts of cases the measure might result in disproportionate interferences in practice. There is a particular approach adopted at the fourth stage of the proportionality exercise, at the balancing exercise. And the question at that stage is whether or not the measure is incapable of operating in a proportionate way, such that it is inherently unjustified in all or nearly all cases. And we set out the authority for that approach in paragraph 66 and 67 of our written case. We address the comments of Lord Mance in paragraph 69 and 70, and we explain why we say that he wasn't establishing the law on this point. But again, as my Lord Reid pointed out this morning, even if one takes Lord Mance's approach, he was still looking at the question of whether or not it was inevitable that in at least some cases there would be a breach of Article 8. So although I suppose his approach to the number of cases differed from the rest of the authority, his approach to it being inevitable or bound to be a breach of Article 8 was the same as, for example, Lord Hodge in the Beebe case. So for the purposes of this case, it doesn't really matter which one of those two approaches one adopts. And then finally, in paragraph 73, we point out the measure won't be incapable of being operated in a proportionate way if it allows for the exercise of discretion in an individual case, and one can exercise that discretion in a proportionate way. So the dispute is whether or not that approach applies not just to legislation, but also to other measures such as policies and guidance. To a certain extent, we anticipated that this argument might be run against us in paragraph 74 of our written case. But can I just summarize the two main points we make there, if I may? Firstly, there's absolutely nothing in this court's case law to support that distinction. And there's nothing in the case law in Beebe, in Lebanon, in Christian Institute, or the Northern Ireland Human Rights Commission case to suggest that the court's approach turned on some inherent quality that legislation has, but that other types of measures do not have. The court's approach didn't hinge on that. It hinged on the fact that one was looking at an in-principle challenge with no concrete facts against which to judge proportionality. That was the reason why the court adopted that particular approach. And of course, the approach, particularly in Beebe, originated in cases that were concerned with the immigration rules. Now, yes, immigration rules are treated as subordinate legislation for the purposes of the Human Rights Act and are defined as such in Section 21. But in reality, and the courts have recognized this, what they are is they are statements of executive policy. They don't have any particular quality that sets them out as having the nature of legislation in that sense. So that's the first point. There's nothing in the court's formulation of the test to be applied that suggests that the distinction between legislation and something else is the key difference. And the second reason is that there's no reason in principle why a different approach should be adopted. The difficulty that arises in relation to in-principle challenges to legislation is exactly the same difficulty that arises in relation to challenges to policy or guidance. There are no concrete facts, as in this case, against which to test proportionality. The court doesn't know whether or in what circumstances the policy or the guidance will actually ever give rise to an interference. And that difficulty, which was the difficulty that the court identified in the legislation cases, applies equally in the cases of other types of measure. Now, as I understand it, the only case that is cited as authority, well, sorry, the only case of this court that's cited as authority for the application of a different test is the Beebe case. And it's important to point out, to show that the argument being advanced by the appellant here has found some roots in the case law of the courts below. And in particular, both of us have referred to the case of W, a decision of the divisional court, W against Secretary of State for the Home Department, where the divisional court drew a distinction similar to the one that the appellant is seeking to draw in this case. And for the court's reference, that's Authorities Bundle 1, tab 9, and it begins at page electronic page 1089. But with respect, both the appellant and the divisional court in the W case have read Beebe incorrectly. Beebe was concerned with the situation where guidance would inevitably result in a breach of Article 8 in particular types of cases. So this doesn't help the appellant. The appellant in this case can't say, and indeed doesn't say, that the guidance will inevitably result in a breach of Article 8 in any case. And Beebe is not authority for the proposition that a mere risk of a breach results in guidance being incompatible with Article 8. Perhaps it might be useful if I just took the court very quickly to Beebe. I don't intend to do the same exercise as I did with Gillick, you'll be glad to understand, but it might be useful just to put this in context. And I think I have time for this. It's behind tab 6 of the first authorities bundle, electronic page 986. And this was a challenge to the immigration rules, and it was a requirement imposed by the immigration rules that applicants for entry clearance had to demonstrate a certain level of proficiency in the English language. So it was imposed by the rules, and the claimants challenged the rules. The claimants didn't actually challenge the guidance on how the rules should be applied in practice. And if I can pick it up, Baroness Hale, her judgment starts at page 990, and Lord Wilson agreed with her. In paragraph 1, she sets out the rules, or summarizes the rules. In paragraph 2, she points out the appellants have set themselves a difficult task in terms of challenging the rules as in principle incompatible with Article 8. And then in paragraph 12, she sets out the relevant provisions of the rules. And then in paragraph 16, she points out that the courts below did not consider the guidance given to entry clearance staff as to how the rules should be operated. So just perhaps 2 points to note about the context for the judgments in Beebe. Firstly, there was no challenge to the guidance. And secondly, it doesn't appear that the courts below had looked at the guidance. Now, the key point about the guidance is in the quote that Baroness Hale sets out in paragraph 16, and it's about discretion for exercising discretion. And it says it should be exercised only in cases where there are most exceptional, compelling, and compassionate circumstances, specifically relating to the ability of the applicant to meet the language requirement, and they should be assessed on a case-by-case basis. The expectation is that the use of the exceptional to compassionate circumstances exemption will be rare. Financial reasons will not be acceptable. So that's the italicized. That was the bit that was said to be objectionable. And it's important to recognize what the guidance there was doing. The guidance was telling entry clearance officers that matters relating to financial circumstances were not a relevant consideration when exercising discretion. It was purporting to rule that out as a relevant consideration. Again, just taking it very quickly, if I may, because most of this is concerned with the lawfulness of the rules, or the compatibility with Article 8 of the rules. Paragraph 29, Baroness Hale sets out the 4-part proportionality test. And then she goes through that, and in paragraph 49, she comes to the fair balance element of the test. And she makes the point at the end of paragraph 49 that the lack of systematic information makes it difficult to work out the extent of the interference with the Article 8 right at a global level. Though it seems clear there's been some effect, it's not difficult to work out the extent of the interference at an individual level. And she goes on to give examples of that. And in paragraph 52, the interference with British partners will be substantial. They're faced with indefinite separation. And then paragraph 53, she says this: the problem lies not so much in the rule itself, but in the present guidance, which offers little hope, either through the exceptional circumstances exception or through the possibility of entry clearance outside the rules. So she turns her attention, she says the problem's not with the rules, the problem is with the guidance on the rules as to how the exception should be applied in practice. And then paragraph 54, and this is the key passage that has been picked up in I think by my learned friend and also in the courts below. She says this, starting at the top of page 1006, given the comparatively modest benefits of the requirement when set against the very substantial practical problems which some will face in meeting it, the only conclusion is that there are likely to be a significant number of cases in which the present practice does not strike a fair balance as required by Article 8. So just pausing there, Baroness Hale is not putting forward a test of significant number of cases. That's her conclusion of the consequences in this particular case. And it's important to go on from likely to be a significant number of cases to read what's going to happen in those cases in which the present practice does not strike a fair balance as required by Article 8. So what she's saying there is it's possible to identify a cohort of cases where the application of the rule in conjunction with the guidance will inevitably be disproportionate. She is not posing a real risk test. She is not posing significant number of cases as the test. What she's saying is, on the facts, on the evidence, the court can identify there will be cases where inevitably this rule is disproportionate, or the way the guidance works is disproportionate. And 55, it doesn't mean the rule has to be struck down. There will be some cases in which the interference is not too great. The appropriate solution would be to recast the guidance. And then we go on to her conclusion at paragraph 60. I would not strike down the rule or declare it invalid. It will not be an unjustified interference in all cases. It is capable of being operated in a manner that's compatible with convention rights. Hence, the appellants must be denied the remedy they seek. However, the way it is operated in light of the present guidance is likely to be incompatible with convention rights of a significant number of sponsors. There may well be some benefit, therefore, both to individuals and to those administering the rules in declaring that its application will be incompatible with the convention rights of a UK citizen or person settled here in cases where it is impractical without incurring unreasonable expense for his or her partner to gain access to the tuition or to take the test. So the declaration that Baroness Hale contemplated was, again, it's not to do with risk. It's not to do with the fact there was a significant or some other number of cases. It's about the fact that she had identified that in a particular cohort of cases, the guidance or application of the rule in accordance with the guidance will be incompatible. It is inevitable. And the reason that it was inevitable is because it didn't allow entry clearance officers to look at financial circumstances when they were considering the considering the exceptional circumstances exemption. And one sees exactly the same approach in the other two judgments. Now, I may take this quite quickly. I'm sorry, I'm taking this quickly, but just to deal with it in the time available. Paragraph 61, Lord Hodge, with whom Lord Hughes agreed, he agreed with Baroness Hale, there's no basis for striking down the rules, but B, the guidance, because of the narrowness of the exceptional circumstances for which it allows, may result in a significant number of cases in which people's Article 8 rights will be breached. So again, he's not posing significant number of cases as the test. That's his conclusion, in line with Baroness Hale's conclusion. The key point is that it's possible to identify a cohort of cases where rights will be breached, where it is inevitable that the guidance will result in a breach. So again, there's no question of risk being applied there. And finally, we see the same in paragraph 77, Lord Neuberger, page 1010. And he agrees with Baroness Hale and Lord Hodge that the appeal should be dismissed. And he says, however, he also agrees that the guidance contained in the relevant paragraph seems to be bound to result in Article 8 rights being infringed on a number of occasions. So again, he's using the guidance is bound, inevitably it's going to result in breaches in certain types of cases. He's not posing a number of occasions as the test. That's the consequences of the guidance. And then again, paragraph 101, I have concerns about the guidance. It does appear, excuse me, virtually certain that there will be a significant number of cases where the application of the guidance will lead to infringement of Article 8 rights. Now, unfortunately, we never got a resolution of BB because, as you saw from Baroness Hale and the other judgments, in fact, the court decided to reserve the question of whether they should grant a declaration, and if so, in what terms, for further submissions. I've sought instructions on this, and it appears that actually a declaration has not yet been issued, despite the fact that the case was obviously heard some time ago. But we don't actually know what the terms of the declaration were or are going to be. But it follows that the BB doesn't support the appellant's argument, and also, with respect, it doesn't support the analysis of the divisional court in the W case. What all three members who gave judgments, all three justices who gave judgments, were focusing on is whether or not the guidance will give rise to breaches of Article 8 in an identified category of cases. It was not laying down a test involving either a risk of breach or a significant number of cases. And the approach that the court adopted in that respect is entirely consistent with the approach that is adopted in the context of the immigration rules in that case, the Lord Hodge incapable of being applied approach. And what is striking about the three judgments in BB is that nowhere in those judgments is there any suggestion that the justices were applying a different test in the case of the guidance than they were to the rules. That is not expressly said anywhere in the judgments. And one might have expected, if the court was, as it were, changing horses midstream and adopting a different test to different types of measures, to have seen that reflected at least somewhere in an express recognition of it in the judgments. But express recognition is there none in the judgments. So again, I'm afraid we say that BB does not support the appellant's case at all. It is consistent, we say, with our case. Finally, in relation to convention rights, can I deal with a point that's in Mr. Southey's supplemental note, in which he came back to today? He's argued that the approach that was adopted by the House of Lords in the Munjaz case should be adopted in the present circumstances. The problem with that submission is that the Munjaz case was a materially different type of case. And again, this is a point that my Lord Reid adverted to this morning. Again, I don't think we need to go to it, but Munjaz was a challenge to a seclusion policy that had been adopted at Ashworth Secure Psychiatric Hospital. In paragraph 78 to 80 of his speech, Lord Hope approached the relevant passage or the relevant parts in this way. And he said he was focusing on Article 3, and he held that Article 3 imposes a positive duty to prevent inhuman or degrading treatment of vulnerable persons, akin to what my Lord Reid referred to in the immigration context, a positive duty to avoid Article 3 ill treatment. And what he said is that that duty would be breached if Ashworth's policy gave rise to a significant risk of ill treatment. So the approach in Munjaz turned entirely on the positive obligation that arises in the Article 3 context. That's why Lord Hope and Lord Bingham applied the test that they did to the policy, is because they were looking at Article 3, and Article 3 requires, as it were, steps to be taken to eliminate the risk of inhuman and degrading treatment to people who are in the care of the state. There is no such positive obligation alleged in this case. And of course, even if there was a positive obligation, it would be the police who had primary responsibility for complying with it. So I'm afraid Munjaz and Article 3 doesn't take the appellant anywhere in this particular case. It's simply irrelevant. So that's really all I wanted to say about the convention rights element of the challenge. And again, to go back to where I started, there are really two ways, I suppose, that the convention rights element of the challenge can get off the ground. Firstly, it collapses back into the Gillick challenge. It's simply another type of unlawfulness that the guidance is said to advise. Or alternatively, the appellant has to show that the guidance is inherently incompatible with Article 8. And that means showing that it can't be applied compatibly in all or nearly all cases. So well, that takes me to my penultimate main topic, which is the case law on procedural fairness. And I think, subject to one point, I don't really think there's any difference between the parties in relation to this. I suppose it would be surprising if on an area that's so well established there was any difference. We've summarised the position in our written case, and if I can just give the court the references, it's electronic pages 103 to 105, and it's paragraphs 82 to 88, and really they can be reduced to two simple points, which we say are fairly self-evident from the case law. Firstly, the requirements of fairness vary from case to case. Whether fairness requires that a subject be afforded an opportunity to make representations is going to depend on the circumstances. And in the context of child protection, there might be very good reasons why a subject should not be given an opportunity to make representations. For example, if that would put the child at risk itself. So that's the first point. The second point, and this is where I think in one respect we might part company, as a matter of law, there is no presumption that an opportunity must be afforded to make representations. I quite accept that the right to make representations is important. I quite accept that in these sorts of cases, it may well be important on the particular facts. I quite accept that the rules of fairness might require an opportunity to make representations in many cases. It might even require it in most cases. But it all depends on the facts. There is nothing, subject to the one point I'm about to come to, in the authorities that suggests that the law imposes a presumption. It has never been discussed in those terms. Even going all the way back to Lord Mustill in Doody, the assessment of what fairness requires depends on the circumstances. Where we part company is the submission that was made this morning, and I'm not sure the extent to which it was fully advanced, that the in accordance with the law element of Article 8.2 somehow imposes a presumption that representations should be sought. But if that is indeed the appellant's case, it is being built on very, very flimsy ground. Two cases were cited in this context. The first was the Blechich case, which again is cited in our written case. But the difficulty with relying on that case is that the European Court, in an Article 8 context, considered the right to make representations as part of the proportionality analysis. The particular passage on which my learned friend relies doesn't come in accordance with the law section of the judgment. It comes in the proportionality section of the judgment. So that was the first case. The second case was the Christian Institute case. But again, as my Lord Reed pointed out this morning, that turned on the very particular facts of that case. There is, so far as I'm aware, no authority to support a general proposition that the in accordance with the law element of Article 8.2 imposes some sort of presumption that representations should be sought. And it only needs a moment's thought to realize that erecting that as part of the in accordance with the law element of Article 8.2 would be a very significant step. Because of course it would mean that there was no proportionality analysis. It wouldn't matter how proportionate it was not to allow representations. It would be a breach of the hard-edged, in accordance with the law requirement, of which no justification is permitted. So, I said, I'm not sure how forcefully Mr. Southey was putting forward that submission, but if he is putting it forward, there is simply no support in the authorities for it, and it would be a very significant step forward. And it would certainly be a very significant step beyond what we know, well, at least we know today, about where Strasbourg has gone. And in those circumstances, I would respectfully suggest that this court should not go there. So, unless there's anything else on the requirements of fairness, that brings me to my final section of my submissions, which is the application of the law to the facts. And I think I can take this fairly quickly. To succeed on the facts, in my submission, the appellant has to show either that the guidance positively advises the police to act in a way that is unfair, or that the guidance is incapable of being operated in a way that is fair in accordance with the Article 8 procedural principles. So those are the two tests that the appellant has to get over on the facts. If the appellant is going to plant his flag on BF Eritrea, then on the BF Eritrea test, the appellant still has to show that the guidance creates a real risk of unfairness in a more than minimal number of cases. And for the reasons that I explained at the outset of my submission, on the facts, the appellant simply can't succeed on any of those tests. In relation to my two formulations of the test, the fact that paragraph 5.5.4 of the guidance positively advises the police to consider seeking representations is a complete answer. That advice accurately reflects the law. It's for the police to consider on the facts of each individual case whether fairness requires an opportunity to make representation. And it enables the police to comply with their own duties in every case. So in a way, although one has the context of the MAPA guidance that I discussed in answer to questions from my Lord Reed before the lunch adjournment, and that is really sort of further reason why the context to all of this is important, because one's not just looking at these things in silo. In a way, unless Mr. Southey can point to something in the guidance which positively advises or instructs the police not to allow an opportunity to make representations, then paragraph 5.5.4 of the guidance is the complete answer to this case. In reality, and I think it's important to grapple with this, the appellant's case, and I think Mr. Southey came close to accepting this, his case on the facts is not that the guidance creates a risk of unfairness, it's that it doesn't eliminate any possible risk of unfairness. But there's simply no legal basis for such an approach. And in fairness to Mr. Southey, he hasn't sought to make good a legal basis for such an approach. But that is in essence what the case comes down to. He's not saying that the Secretary of State got the guidance wrong in the sense that it misstates something or it provides erroneous advice or something of that sort. What he's saying is, well, it doesn't go far enough. It should set out chapter and verse on the requirements of fairness. But that can't be a basis on which guidance such as this is unlawful. In terms of the specific points that my learned friend made this morning, I'll deal with them fairly quickly. Firstly, he referred to the fact that the guidance alerts decision makers to the possibility that there might need to be immediate disclosure in some cases. Well, yes, but that's clearly qualified by reference to an imminent risk of harm to a child. And that simply reflects the well-established principle that fairness might not require an opportunity to make representations in urgent cases. And again, to pick up on the point my Lord Reed made this morning, of course, this guidance is directed at protecting children from harm. It's about specific children, a specific child or a specific children, and protecting them from harm that is posed by a specific individual. So in my submission, it's perfectly legitimate to alert the police to the fact that urgent action may be taken, and that is a perfectly conventionally reason why fairness might not require representations to be made in a particular case. The other point that the learned friend makes was on paragraph 5.2.9. It was this point that applicants under the scheme should be assured that the inquiry will be dealt with confidentially, pending the outcome of the process. But one has to read that paragraph as a whole. In the very next sentence, it goes on to say that the police have to tell them that if they think there are concerns in the particular case, they're going to need to think about telling the subject in order to get representations from them. Now, of course, the guidance might be better worded, and I'm sure the court would be able to come up with some better wording, but reading that paragraph as a whole, it can't possibly be read as somehow giving an instruction to the police that the requirement to think about seeking representation is somehow trumped by an assurance of confidentiality that's given to the applicant. So neither of those points in my respectful submission mean that the guidance advises the police to act unfairly. Neither of those points means that it's incapable of acting unfairly. And even if the court were to find in favour of the appellant on the law, neither of them creates a significant risk of unfairness in a more than minimal number of cases. So I think that brings me to almost dead on 3:30, which I think is the end of my time. I'm just, if I may, just see if I'm going to get any more electronic kicks under the table to say something else or to qualify anything that I have said, if I may. I'm not receiving anything. It might be there's a delay. But I think for the time being, at least, I can say, unless there's anything else that I can help the court with, those are the Secretary of State submissions.
Thank you very much, Mr. Muffet.
My Lord, can I then respond? Sorry, I should have been. Sorry, I was getting ahead of myself there. My learned friends, I'm going to deal with my learned friends submission slightly out of order, in part because of the focus, an understandable focus on the nature of challenges, the challenges brought. And to put that in context, my learned friend ended by saying essentially his primary case, though he submitted he could meet a higher case, was that I have to demonstrate that the policy positively advises or is incapable of being read in a manner that is lawful. Positively advises illegality, I should say, or is incapable of being read in a manner that's lawful. In our submission, that is a far too narrow test, and we say that for 3 reasons. The first, which we would submit isn't inconsistent with conventional public law, is that underlying the claims of this nature, the claims that have succeeded, for example, in Court of Appeal, where what I've described as the unacceptable risk test has succeeded, is the fact that someone is relying on essentially either statutory right, a right established by the Human Rights Act, or a common law right, an absolute common law right, such as procedural fairness. And striking, I think, at one point, if I remember rightly, if my notes are accurate, that where my learned friend sought to explain the Director of Legal Aid casework case, he sought to explain that, which is in this sort of category of unacceptable risk cases. It's not one we've seen, but he used the language that it was a case concerned with interference with fundamental rights. And my lord, that is the case here. Here, one's talking about both a right recognised under Article 8 and a right recognised under the common law, effectively a right to privacy. I mean, that's the origin of the ex parte AB. And that demonstrates, I should say in passing, one thing we would urge, which is in our submission, it is slightly dangerous to separate out the HRA from the common law issues. The principle we're relying on has essentially been developed, we submit, through domestic public law, but it does arise in particular in the context of convention rights, and it arises in that context for the reasons I've already indicated, which is that the right, essentially the right to compliance with Article 8 is an absolute right, absolute in the sense that one can't violate it. Obviously, I accept Article 8 is concerned with proportionality. The second reason we say that is the approach we're adopting is right, is it is consistent with a long line of recent authorities, and we haven't been through all of them. I'd like, though, given my learned friend's submissions, to spend a little time on Bibby, because in my submission, Bibby is of some importance for a number of reasons. My learned friend says that the test applied was not effectively significant number of cases. In our submission, that is wrong, because where all 3 judgments look at this issue, they do so essentially to see whether or not the guidance that's currently in place is lawful, essentially, or is acceptable. And so Baroness Hale, perhaps most importantly, if one goes to page 1006, which 1006, which is at tab 6 of the primary authorities, she reaches the conclusion that there is a significant number of cases. Paragraph 55 then refers to the need to recast guidance. And this is what she says about the guidance that needs to be put in place. The guidance should be sufficiently precise so that anyone whom it is genuinely impractical to meet the requirements can predictably be granted an exception. So what she's saying is there needs to be guidance, essentially, which addresses this problem of a significant number of cases breaching Article 8 because the guidance doesn't facilitate. She's looking essentially to eliminate that significant number of cases by having sufficiently precise guidance. Well, that is how it was understood by the Divisional Court in W. We haven't taken you to it. That is essentially the basis of BF, and I will potentially come back to BF. I should say these weren't passages that you were taken to. I just asked the court also to look at paragraph 69, Lord Hodge, who paragraph 69 indicates there may be cases in which the operation of the rule in the terms of the current guidance will not strike the fair balance, but there may also be many cases in which it will. So he's looking at a situation where on his findings, essentially it is not a common thing necessarily that there will be an issue, but he again holds that that is sufficient. That's the trigger essentially for Article for the need for revised guidance, and he clearly reached that conclusion at paragraph 74. And Lord Neuberger, paragraph 101, explaining why he has concerns about the guidance. He does that on the basis that there will be a significant number of cases. That's how I won't take it the court to. I'd ask the court to read the Divisional Court in W. That's exactly how the Divisional Court in W understood Bibby. And that, as I say, is consistent, we would submit, with the other line. Now, that is not inconsistent in our submission with Gillick, and in particular, the permit test. In our submission, the permit test, if guidance essentially is foreseeably going to result in a significant number of cases that result in an unlawful outcome, that is effectively the guidance permitting that. And I asked the court just to turn to Lord Scarman at paragraph 869, sorry, page 869, which is tab 3 of the core bundle. My learned friend took the court to this passage. I didn't this morning, but it's important to understand it because it is not consistent in my submission with my learned friends in submissions, and that's where Lord Scarman, as the court saw this morning, saw this afternoon rather, concluded that that there would be an issue essentially if the vagueness in a policy meant that it could be reasonably understood by the doctor as authorizing him to prescribe without the parent's consent whenever he thought that he should think fit. Excuse me for a minute. That, in my submission, is entirely consistent, essentially, with there being a risk. It's not a situation where the guidance necessarily compelled that conclusion. It's a situation where the guidance was insufficiently precise that it would have permitted that conclusion. But whether or not...
Mr. Southey, sorry, just before you move on from that point, I mean, surely you have to read that with the earlier passage where Lord Scarman says that the issue is what is the true meaning of the guidance. So he's there in the passage you've referred to at 869, as it seems to me, saying that it's possible that guidance might be posed in such an obscure way as actively to lead one to conclude on its true meaning, that it is telling a doctor that they can treat themselves as authorized to prescribe without the parent's consent whenever they think fit. In other words, without limits as have been spelled out by Lord Scarman earlier in his speech.
Well, my Lord, with respect, what in my submission he is doing there is dealing with, I mean, on the facts, he because there wasn't the sort of situation he's describing at page 869, he wasn't adopting that approach, but he is recognizing that in principle, guidance can mislead essentially somebody as to the true legal position by being insufficiently precise. And that must be right, my lord, in my submission. I mean, if you think about the reason I say that is and it goes to another point that my learned friend made. My learned friend said that in relation to Gillick, essentially, that one needs to recognise that in relation to provision of advice, there are limited grounds of challenge. And in our submission, what that fails to account for, and this may be a development of modern public law as well as modern public administration, is that in situations like the guidance in question in this case, what central government seeks to do, not unreasonably, is provide a comprehensive guide essentially as to how functions should be exercised. And when it does that, it potentially can cause misunderstanding about the true legal position. And if it does that, because it's perfectly reasonable for actual decision makers to rely on that guidance, that potentially leads to illegality. I mean, the distinction between this case and the Bayer case is the Bayer case essentially said, we're not going to tell you what to do in relation to this function, so far as relevant. Here, the policy essentially is trying to prescribe a complete policy that should be followed for understandable and good reason, because obviously it's important that that this decision making takes place based on consistent practice, good practice. But my lord, whether or not I'm right about that, one also in my submission has to recognise, as my learned friend did in his submissions, that public law has moved on, and public law does recognise the sorts of rights that are contained in the Human Rights Act and their absolute nature, essentially. Now, my learned friend, that is in our submission why one gets to BF Eritrea. My learned friend sought to distinguish BF Eritrea, and we haven't taken the court to it. I haven't taken the court to it, rather. It's at core authorities, or primary authorities, tab 5, page 975 to 976 is the critical passages. And I should make it clear, we don't certainly argue for anything more than the ultimate test identified by Lord Justice Underhill, and that test is essentially in the last line of paragraph 63, which is a risk. The terms of the policy create a risk which could be avoided if it were to be better formulated. And my learned friend seeks to distinguish BF Eritrea, and he refers to the fact that Lord Justice Underhill referred to the approach being in the circumstances of this case. But as it's quite a common formulation, of course, and it causes one in my submission to ask, what were the circumstances of this case? And the circumstances of the case, the relevant circumstances in our submission, is that it was a policy, again, effectively intended to prescribe the approach that should be taken to decision making. And that's why in recording the argument, for example, from paragraph 60 onwards, what Lord Justice Underhill does is set out a number of cases, all to do with this issue of essentially unacceptable risk. My learned friend, second distinction is to point to the fact that Lord Justice Underhill said at the start of paragraph 63, he didn't find it necessary or useful to analyse the cases. What he's referring to in our submission there, which one sees in paragraph 62, is the fact that quite clearly from paragraph 60 onwards, there'd been lengthy submissions between 3 parties who were involved in the case as to the correct approach in this context. And actually what Lord Justice Underhill thought or found quite clearly was that actually all these cases were broadly consistent and resulted in the test in question. And that's why he didn't find it useful. One sees, for example, at paragraph 62, where there's argument. The third and more fundamental criticism of my learned friend makes is essentially it's not grounded on public law. But in my submission, I go back to the principle, the point I made previously, which is as a matter of principle, where one is talking about rights such as those in issue, there clearly has to be, there is a clearly positive duty to ensure that decisions are taken lawfully. The Human Rights Act doesn't permit violations of the convention in this sort of. That also is the context in our submission of that's also to say the submissions I've just made perhaps should be in my submission viewed in conjunction with the submissions in relation to Article 8. My learned friend's submission is a policy like this can only be challenged on the basis that it positively encourages a breach of the Article 8 of Article 8, or it is in what his language was inherently incompatible, and by that he appeared to mean that it was inherently disproportionate. Firstly, in our submission, that glosses over or ignores the requirements for a policy to be in accordance with the law in this sort of context. This is a context where the policy essentially is the sole safeguard to ensure proportionality, and it needs to do that. That is the approach in Christian Institute, that is the approach in P. And one of the reasons why in our submission representations are so important is because they ensure that a decision maker has the material to assess proportionality. But secondly, as Bibby it demonstrates, it is open to somebody to complain essentially or challenge a guidance on the basis that it results in foreseeable number of violations of the convention on proportionality grounds. And can I just take, I went to Christian Institute this morning in opening in relation to in accordance with the law, but it's important not to lose sight of the proportionality approach. And if one goes to core authorities or primary authorities, tab 2, paragraph 96, page 827, one sees there that the court was satisfied essentially that the legislation could be read compatibly with convention rights, unsurprisingly, because it didn't prevent consultation. It was satisfied with that, even though at paragraph 100, it didn't point to a fair balance. And that led the court to note the need for guidance, essentially, to ensure proportionality. And that's at 101. Now, that's why, in passing, so I don't have to come back to it, we say there is a difference between, for example, legislation and guidance, because in reality, guidance fills in the gap. But that led, effectively, that was the context of a finding at 106, which is that where the court concluded at paragraph 106, letter D, that there may in practice be a disproportionate interference. And so what followed from that was the need for guidance, essentially. And so it's again an example in the context of proportionality of may in practice being the correct approach. And that doesn't result in our submission in practical difficulties. It's not about hypothetical examples. What we're arguing for is something that the court is very familiar with, which is it assesses the terms of a policy and it considers essentially whether, in light of the correct legal position, there is a risk that someone applying the policy will take unlawful decisions. And there are a number of examples I won't take the court to of situations where the court applying this test, the sort of BF test of is there a risk, has looked at the terms of a policy and reached the conclusion essentially it was unlawful. Two examples, volume 3, tab 28, page 1781, detention action. The test applied was by Lord Dyson, I think, if I remember rightly, in the Court of Appeal, paragraph 27, Roman 3 was a system will be unlawful on the grounds of unfairness if there is unfairness inherent. So it then looked at what the time limits were, because the complaint was the time limits, and that was paragraph 45, without looking at specific examples. More specifically, FB in the Court of Appeal, which is a judgment my Lord Burnett will be familiar with, having sat in the case. If one looks at FB at tab 31, rather, volume 3, page 1917, the court expressly said that although systemic unfairness may be illustrated by individual cases, one needs to focus on the scheme, paragraph 120. I think, to be fair, that was the lead judgment. I don't think it was. I think, but yes, I'm getting, I think, agreement from Lord Burnett, but anyway. But the key point about that was it shows the court looking at the terms, or certainly the lead judgment looking at the terms of the policy. And that's the critical point. Is my learned friend says there's nothing in the guidance that says one shouldn't seek representations. But ultimately, as my learned friend also says, that leaves it to the police, but it implies it's discretionary. And it implies it's discretionary in circumstances where the policy itself is meant to be self-contained. It's plainly meant to be self-contained. I'll come back to that in a moment. And where, in our submission, the correct approach is that the norm, which is a presumption, should be that there is disclosure. There are representations, rather. Can I just refer to the policy? I won't take you to it because of time again, but refer to electronic page 361, page 220 of the original appendix, which is paragraph 2.6, which my learned friend referred to, which is the relationship with MAPA. The critical point that my learned friend didn't take you to was that the passage above that, which it sort of introduces that bullet point, says it should be stressed that the disclosure scheme builds on existing procedures as outlined below and will provide a clear access route to the public to raise child protection and be confident that action will follow. So what it's saying, and then it sets out, it refers to the MAPA guidance. So what it's saying is this is a standalone policy that you read this and you'll be complying with your obligations in our submission. And that's consistent with, of course, the point I made this morning, which is that the MAPA guidance says this is a standalone policy. I should say in passing, we don't accept necessarily that, as my learned friend, to be fair, fairly accepts that disclosure in this case would necessarily be governed by section 327A for reasons broadly that my learned friend gave, which is that 327A imposes quite a specific test. I would also say, as recognised by the Divisional Court in the applicant's first judicial review, there are issues about whether 327A needs to be read in a different way to ensure compatibility, whether ultimately it needs to be read as requiring a balance. And of course, the MAPA guidance itself says that the real test is balance. But further point I should make about this, just again for the court's note, in terms of the MAPA guidance, my Lord Briggs referred to essentially the fact that the guidance identifies 2 cases, one of which is streamed into MAPA. One needs to be a bit cautious about that, just in passing, because this would be a level 1 case almost certainly, in which case essentially what the guidance says, and it's page 500 of the electronic bundle, is that the review has to be in accordance with the policies of the lead agency. Page 452, that is the police. So the starting point essentially is to put the decision making back on the police, because it is effectively the police who would be managing someone like this who long ago finished the service of his sentence. Finally, or almost finally, my learned friend accepts in terms of policy, procedural fairness, that there will be many cases where consultation is required. What he says essentially is that there may be cases where, for example, there are good reasons. He doesn't accept that's a presumption, but it's striking that essentially whenever this is expressed as this duty is expressed, it is expressed essentially as looking for whether there are reasons not to consult. And in our submission, that both reflects the importance of what is in issue in this sort of context, and also the fact that the subject of the disclosure may have something to say. Now, in that context, we should make clear, didn't suggest, I don't think I suggested, that Bleckett was simply about in accordance with the law. It is a point which I accept is dealt with in terms of proportionality, but the key point about it is its starting point is it requires involvement of the individual in the decision. And in this context, if there's no consultation, there won't be involvement. In accordance with the law supports those arguments because it makes it clear there needs to be safeguards to ensure proportionality, and consultation will be one of them. It's a supporting argument, and that's where I referred to Christian Institute and indeed its endorsement of Lord Reed's judgment in, or it following Lord Reed's judgment in P. So we submit procedural fairness is essentially a norm, and that, coming back to it, is the problem here. The policy is very unclear. It suggests essentially a discretion. It states in terms that there will be confidentiality, and it is unclear at the very least about how that conflict between confidentiality and the need for procedural fairness should be resolved in circumstances where, as I say, the general provisions of policy are clear about consultation essentially being discretionary. My Lord, I think that's on my clock, it's 3:59. Can I just turn to those metaphorically behind me and wait? And again, as with my learned friend, unfortunately, the time delay means I think it may take about a minute for them to catch up and tell me whether or not there's anything else they want me to say. I've had the virtual sign-off and approval for what I've said, which is a relief. Thank you, Lord.
Well, we're very grateful to all counsel for their submissions. The appeal obviously raises an important issue in public law, and we'll now take time to consider our decision. and issue our judgment in due course. Thank you very much. Court will now adjourn.